essentially informed consent and the case law relating to that. So to refer specifically to the relevant provisions of the National Health Act, and it's pretty specific. Section 6, every healthcare provider must inform a user, it's peremptory, of the user's health status, except in circumstances where there's substantial evidence, the usual therapeutic privilege, it's better the patient doesn't know. The range of diagnostic procedures and treatment options generally available to the user, and we're going to come to certain drugs where there's been litigation internationally. The benefits, risks, terms and consequences generally associated with each option. And as we all know, and as I've heard this morning from the very interesting speakers, there are so many options for so many different conditions. Do you use lithium in a child that's perhaps not quite manic, but it's got the typical symptoms of attention deficits disorder and perhaps is excitable? The user's right to refuse health services and explain implications, risks and obligations of such refusal. And significantly, the Act says that the healthcare provider concerned must inform the user in a language, very important in our context, our multicultural and multilinguistic South Africa, that the user understands and in a manner which takes into account the user's level of literacy. That's so important, and I'll just share some tips as to how I think you can deal with that. Section 7 deals with consent of the user, and it says a health service may not be provided to user without the user's informed consent. And then it gives the exceptions, and it's usual emergency of no one's available, the person's not in a state to give consent. And Section 8, participation in decisions. A user has the right to participate in any decision affecting his or her personal health and treatment. 9, health service without consent, and you can't do it, subject to very specific exceptions. And 10, very interestingly, discharge reports. Healthcare provider must provide a user with a discharge report the time of the discharge user from a health establishment containing such information as may be prescribed. The Minister has prescribed the regulations. It's basically the diagnosis, the treatment which was given, and the prognosis. I think in the psychiatric context, and certainly in the context of Cipla, which is a renowned drug company, health services for experimental research purposes. So you can't decide yourself, or yourselves, perhaps a group of psychiatrists, well look, let's in Boksburg do a trial on this drug as opposed to that drug, as opposed to a blind study, and let's see what results we get. And we won't tell the patients, why do we need to bother? And it makes provision that before a health establishment, and I believe one could read into that, a health provider, provides a health service for experimental research purposes to any user, the health establishment must inform the user in the prescribed manner that the health service is for experimental research purposes, and so on and so forth. So it goes on. So it's a pretty specific act, and I think one ignores that as a medical practitioner at your own peril. Now, what's informed consent? What are you supposed to tell the patient? Well, the case law is that it's those risks which a reasonable person, having been informed of the risks inherent in a particular procedure or course of treatment, would regard as material and would act on such information one way or another, either go for the treatment or decline it, which is quite an elastic definition, how long is a piece of string. But in essence it means that if the patient, having been informed of what's regarded as material risks in the context of the procedure, gives evidence to say, well, if I'd been told that, I might well have declined the procedure, or I might well have sought a second opinion, or whatever, then the court would regard it as material, and therefore it is a risk which should have been disclosed.